I will turn over the presentation to David Freiberg from the Justice Center.
All right. Thank you, Davin, and good morning. This is going to be, we're going to kick off this summit. And this is my second year in a row kicking this summit off because we're going to start talking about incidents. And we all know that the life cycle of a Justice Center case all starts with an incident. All right, so first we're going to talk about taking the report. Mandated reporters must report reportable incidents involving vulnerable persons. Incidents may be reportable even if the individual receiving services does not actually suffer harm. And so when a report is made, right now we're just going to mainly speak about when someone calls our VPCR hotline. And when that call is made, a trained representative will answer, and they're going to collect information from the reporter and give that caller an incident number. Those reporters are protected by confidentiality laws, and all of our calls are recorded and monitored for quality assurance to ensure that we are providing the best customer service to anyone calling to make a report. So what to expect if you reach one of our VPCR hotline agents? So first we're going to ask, is this a current 911 emergency? And if so, we're going to ask you to please disconnect from the call 911, and then give us a call back when it's safe to do so. And if it is not a 911 emergency, we're going to go into the information required for us to make a report. So we're going to ask information regarding the victim, subject, and witnesses. And then once we have that, we're going to go into details of the incident. And we're going to be looking for dates, times, location, and a description of the incident. The description is very important. Our agents are equipped with information gathering tips documents where they can use as a resource when they're on the phone with a reporter, and it kind of gives them an outline of specific questions to ask regarding a whole host of different scenarios. So we'll be looking to get as much information as possible. They're also going to ask for the responsible state agency. Is this an OPWDD provider, an OMH, an OASAS? From state ed, we're going to need that information also so we can notify that state oversight agency about this incident that came in. We will ask the name and address of the provider agency, facility, and/or program. We will confirm that immediate protections are in place for the victim. And we will look for name, title, and contact information of others who may have the same information as you. And any other information that may assist with the investigation or the review of the incident. So we average about 14 to 16 minutes per call. I know that may seem like a lot of time, but our agents are trying to get as much information as possible on that one call. We do have a multiple reporter requirement, and this is regarding when there's multiple reports regarding the same incident. You're not required to report that incident if you're a mandated reporter and you're aware that another individual has made that report. So we'd only be looking for one report on that. And by all means, if you're a mandated reporter and you don't know if it has been reported, please go ahead and do so. If it has been reported, we can go ahead and we can link those two reports and send them out as a package. And so after all that information has been obtained, a report is made. And then we need to classify that. So there are two separate classifications. One can be a reportable incident, and that's either going to be an abuse and neglect or a significant incident, or it's going to be a non-reportable. We have people that call the hotline looking for information on some of the services that the Justice Service may provide, or it does not reach the threshold for a reportable incident, and that's going to be considered a non-NYJC incident. And just because it's a non-NYJC incident, it could be because we don't have jurisdiction over that particular program. We don't have jurisdiction over that victim or that subject, or it just doesn't meet that threshold requirement. But we do still take a full report on those. We do still send those out to the responsible state oversight agency for their investigation. So those are just as important as the abuse and neglect and the significant incidents. Right, just a look at some of the reports made in 2024. The Justice Center took 87,894 reports in 2024. And out of those, 14,260 were classified as abuse and neglect. Another 30,000 were significant incidents. We took 1,609 death calls, and 30,516 were classified as non-NYJC, non-New York State Justice Center incidents. And then another almost 11,000 were not an incident. So just to give you an idea as to the volume of reports that we get every year. And we'll talk about significant incident classification. So each state agency has unique definitions of significant incidents. The Justice Center works with all state agencies to ensure classification of incidents adheres to the regulatory standards for each agency. If a incident reaches that significant incident threshold, we do, we'll take that report, we'll send it out, and then it is on that specific state agency to ensure that that investigation is completed.
Hi, Dave. There's a few questions that we have.
Sure.
The first one is, why does the Justice Center ask for the date of birth of a reporter when a report is made?
All right. We want to ensure that all of our contacts have as much information as possible. And another reason why we do ask for a date of birth is because if there is additional information that's obtained from that reporter and they wish to call it in and make an update, only the original reporter is allowed to update a report at the Justice Center. So we will be asking their name, their date of birth, perhaps their phone number, and we'll go into our system to ensure that we do have the original reporter on the phone. And after that, we will take that update.
Okay, thank you, David. The next couple I think I can answer. So one person wanted to know, how if a victim is in or a witness, a person who's receiving services, leaves the program, how do we, handle making sure they might still want to talk to us or make sure that we talk to them at a convenient time. And I just want to point out that later in this presentation, you're going to see the contact information for our individual and family support unit, and those advocates will help assist and work to make sure that with the investigator to make sure that if we're talking to somebody that we've talked to them beforehand and we're doing it at a time and a place that is convenient for them. Somebody asked if they would get a certificate of attendance for this, and no, we do not issue certificates of attendance. There was a question about the volume, the amount of reports that we received in 2024. How does it compare to 2023? It's pretty comparable. You can go on the Justice Center's website. We post all of our annual reports, and we also post monthly data reports, so you can take a look at that yourself. And then one last question, can mandated reporters make an anonymous report? David, do you want to answer that question?
Sure. Yes, we will certainly take anonymous reports. During the report, we will ask if they are willing to provide their name and their phone number on the recording, and that will not appear anywhere in any written report that leaves this building. However, if that incident is assigned to the Justice Center, our Justice Center investigators do have the ability to listen to the call and get that information and reach out to them if they choose to speak with the Justice Center investigator. It, it is very, at least I believe that it's so important to speak to a reporter because they have the firsthand knowledge of the report. They may have witnessed something, and all of that information is critical in the investigation. So yes, we do take reports, and we will, if that information is provided to us, it will be relayed to a Justice Center investigator, and that is it. It doesn't leave this building. I just want to be clear on that.
And we also don't let if when you make a report to the Justice Center, you're not going to find out information about what happened to the report. We keep that's confidential. It's between the subject and the service provider. Just a couple other things. There was a question about jurisdiction. The Justice Center has jurisdiction over programs that are licensed or operated by certain state agencies. So that is something that we always have to do because we don't have the jurisdiction to investigate everything. But a licensed agency by OPWDD, for example, would be reportable to us. Finally, one last question is an agency not following regulations reportable to the Justice Center? The answer to that is it depends. Was there a risk of harm to the person receiving services? That's really the baseline for reporting to the Justice Center. Was there harm or risk of harm to people? Because we want to look into those incidents and take steps to prevent them from happening again. All right, that's it for now. We can carry.
All right, thank you. So now we're going to talk about classification and assignment of those incidents. So our incident management unit receives all cases of abuse and neglect death assigned to the Justice Center. We're going to gather additional case information as needed, and then we'll determine a case assignment. That assignment might be to the Justice Center, or it may be to a state oversight agency such as OPWDD or Office of Mental Health. And we are also going to ensure that notifications are sent to law enforcement and district attorneys. So all state oversight agencies are notified of all reports we receive. So when a case is assigned to a provider for investigation, the notification includes an investigative strategy memo. This went into effect just a little over 4 years ago, and it was a culmination of a few different factors. We were receiving investigations that were completed by providers in the abuse and neglect world that were kind of missing the mark a little bit, and those investigations needed to be sent back for further information or documentation. So we devised these investigative strategy memos to go ahead with those cases that go out. And in the end, it did improve in improved communication, and they are classification specific. So if it's a physical abuse that goes out to a provider for investigation, that strategy memo is going to be very specific to physical abuse. And it just provides investigative guidance for the investigators out there in the provider world. And I can say that, this has been in effect for a little over 4 years, and the amount of cases that needed to be sent back for further investigation has reduced dramatically, and the overall quality of those investigations has improved dramatically. So I think it's definitely a win-win for everyone with the introduction of the strategy memos. Right. Also under the Office of Incident Management is the 3-day business review team. What this is, it allows the Justice Center to conduct a preliminary review of allegations using an evidence-based approach. The participating providers are OMH, OPWDD, OASS, OCFS, and SED. In 2024, there were 5,760 reports assessed. 62% of those reports were reclassified as a significant incident or a non-NYJC incident. So the unit is in fact called the 3 business day review. Some of you may recall it as the 72-hour unit, but the 72-hour unit did not take an account for the weekends or holidays. So it was thus the 3 business day review. And 3 business day is, it's definitely, listen, if an investigation takes 4 days, that's okay as well. It doesn't need, our goal is to complete those preliminary reviews within 3 business days. But if you require an extension, if you are having some difficulty obtaining the documentation that's requested, feel free to reach out to the investigator who is reviewing the case and just ask for an extension. They're almost always granted. And we would rather have all the information to make an accurate classification than some of it and not make the accurate classification. So some of the benefits for this 3 business day review is the increased accuracy of incident classification. Appropriate safety measures are readily enacted when our notifications go out to the state oversight agencies. They are tasked with ensuring that immediate protections are in place. It has reduced the length of the time of provider staff are out on administrative leave, and it decreases the provider staff unnecessarily placed on administrative leave. And it narrows the scope for investigative resources, reduces cycle time for all abuse and neglect investigations.
Hi, Dave. There's a couple questions.
Sure.
Can a report be made on something that you hear about rather than something that you have firsthand knowledge about?
It absolutely can. Yes, we will. We take all reports here at the intake unit, and then we go ahead and decide where that incident is going to go. But yes, we will take those.
Thank you. Someone asked if the Justice Center also receives calls regarding New York City providers, and yes, we do. If you are licensed or operated by any of the state oversight agencies, by that we mean Office for People with Developmental Disabilities, Office of Mental Health, State Education Department, also known as SED, the Office of Addiction Services and Supports, et cetera, those agencies that license and operate programs are required to report to us no matter where they're located. Does the Justice Center send notification when investigations are, that's not a good question for this. What factors are evaluated? We're going to cover this in the next section on investigation about how we decide whether we investigate or the provider does. And we are sending out contact information for people at the end of this so they'll know who to contact. And I believe you already covered what goes into the 3 business day reviews. Okay, could you just maybe, Dave, one more time tell us what decides whether a report should be classified in the 3 business day review?
Sure, thank you. Yeah, any incident that on face value reaches an abuse and neglect threshold has the possibility to go to 3 business day. We will send incidents through that unit when there are unknowns, such as we don't know the victim, we don't know who the subject is. There may be a video that is available, and we will request that and review it, especially when it comes to any type of restraint or anything like that. It's always good to get a unbiased set of eyes on a video, and we'll take a look at that. We do have some that are classified in our special handling guidance for particular reasons that we will send out, or we will send through 3 business day.
Okay, thank you. And before we go on to the next section, I just want to call out, some people have been asking questions about, mortality reports that are sent to the Justice Center, when and how and who does it. We have a whole section on mortality review, so just hang on and hopefully those questions will all be answered for you soon. All right, Mr. Ryan, it's all yours.
Okay, thank you, Davin. Good morning, everybody. My name is Tony Ryan. I'm the Chief of Investigations here at the New York State Justice Center. I'm going to take you through some things here that hopefully provide you a little bit of an overview of how investigations are handled by the Justice Center. So the cases, as in Dave Freiberg's lead into this, was very good. We appreciate that, Dave. Reports that are the most serious and egregious in all programs the Justice Center will handle. The Justice Center will also handle any of the cases of abuse or neglect that are in OASIS and SED programs. We will also handle any and all investigations in state-operated OCFS, OMH, and most OPWD facilities. Reporter information is confidential in Justice Center investigations, and the Justice Center cannot release reporter information when investigations are delegated to state oversight agencies or providers. I think one of the strong qualities of a lot of our staff here at the Justice Center, but particularly in our Office of Investigations, is that many of our staff had previously worked in the provider settings. We also have many of our Justice Center investigators and staff have family that have been served by providers under our jurisdiction. All of our investigators receive continuous training throughout the year, and we also have annual required trainings of all our investigators. So during our investigation, if somebody is named as a subject in our investigation, they'll receive a subject notification letter from the Justice Center identifying them as a subject in this investigation. During the course of our investigation, we would conduct interviews of all relevant parties, gather information, any video of value that is available. We'd like to obtain all of that to be able to conduct a thorough, complete investigation. On our Justice Center website, it will provide you a more detailed explanation of reporting of the incidents, our investigative process, our appeals process, and also offers quite a bit of online training. As was mentioned earlier, I think there was a call that came into the chat. One of the units that we have here at the Justice Center is our individual family support unit. And that unit has, multiple purposes, but one of their core functions is to work with the individual in the program and offer them support during the life of the report, during the life of the investigation. The individual family support unit also will work with the families of those being served here under our programs and help them give an understanding of, kind of guide them through the process, because some people may not be entirely familiar with the Justice Center process or investigations as a whole. This unit does an outstanding job working with those families and working with those individuals. Some of the specifics they do, they'll make referrals and serve as liaison. They offer responsive and efficient communication. They conduct outreach. They track data and information, and they've helped over 19,000 unique individuals. The specific hotline for the Justice Center is listed here on this PowerPoint. We also have the email address for our support coordinator here at the Justice Center. And as stated earlier, these PowerPoints will be available for after the presentation. As stated, the investigative process is available on our Justice Center website, and it gives a very detailed explanation of our investigative processes and assist for the individuals and their families.
Hi, Tony. There's a few questions that came in for investigations.
Right.
So hang on, let me bring them over. Okay. So when does the Justice Center inform the subject exactly what they are being investigated on, or does it leave it up to the agency to inform the staff?
Well, during our initial notification, we notify them that they've been named in an allegation. And generally, you know, with the protections that are put in place through the agency, the subject is informed of some more of the specifics. Generally, in our cases, the specifics are detailed at the time we are interviewing the subject.
Thank you. When interviewing victims, witnesses, and subjects, could you clarify why a provider should not be interviewing people if it's a Justice Center led in abuse neglect case?
Absolutely. So we prefer to take the lead in those interviews and of the witnesses. It's just to ensure the integrity of the case. Sometimes, you know, people within a program being interviewed by, you know, somebody in a leadership position at their agency, they may be reluctant to, you know, disclose what they saw or what they were told. And if the case were to become a criminal investigation, any and all those communications are required to be turned over, you know, through the court process. So it is just better if the Justice Center is the sole entity that is conducting those interviews.
Okay, thank you. There was a question about, you know, can we report just specific incidents or policies or patterns that we think are could lead to adverse events? We tell people, if you are concerned about something and you think someone should look into it, you can report it to us. We may not investigate it, but we will refer it to the place that that can take a look at it. So go ahead and contact us if you're not sure and you want someone to look into it. And I think that's, what if law enforcement is doing an investigation? Can the agency still do an investigation?
How about the Justice Center or the provider agency?
The provider agency.
You know, again, in those specific circumstances, it is best if law enforcement has the lead in any investigation. The administrative investigation will still be, you know, there'll also be a corresponding administrative investigation that'll be conducted by the Justice Center. But in those situations, particularly, it is best if the agency does not conduct any type of interviews of the witnesses.
Okay, thank you. There have been a number of questions about data, how much this, how this. Our website has monthly data reports and annual data reports. We encourage you to go look at that and find that out. And then there have been some questions that are specific to specific types of providers. And once again, we would ask that you get contact information at the end of this, and you can ask those very specific questions more appropriately. In the interest of time, we're going to move on to case review and closure.
Thanks, Devin. Good morning, everyone. My name is Serena Sturman-Pupons. I'm one of our deputy counsels, and I oversee the 2 units that I'm going to be talking about today. So our first stop here is case review and closure. So the case review and closure unit is responsible for reviewing the Justice Center reviews all investigations and makes a final determination and notifies the parties who are involved and oversees corrective action plans as appropriate. Within the Justice Center, the case closure unit is the unit responsible for determining whether a case is substantiated or unsubstantiated under certain circumstances. So if the allegation is classified as unsubstantiated, then that finding is not publicly available. It cannot be accessed by future employers. If a final determination is substantiated, then it is going to be classified into one of 4 categories. So we're going to start at the bottom and work our way up. So category 4 findings. These findings are made against a facility or provider agency. They're not made against a specific subject or custodian. There's two circumstances where you would see a category 4. One is if a staff member would have been responsible. However, their responsibility or culpability was mitigated by a systemic problem or issue at a facility or provider agency. The other is if there is an abuse or neglect finding that is substantiated. So it is determined that abuse or neglect occurred, but the perpetrator can't be identified. Category 3 findings. These are substantiated findings of abuse or neglect, but the level of conduct does not meet the definition of a category 1 or 2 finding. These are not publicly available. They cannot be accessed by future employers. Category 2 findings. So category 2 findings include conduct in which the custodian seriously endangers the health, safety, or welfare of an individual receiving services by committing an act of abuse or neglect. The two things about category 2s that are specifically unique is that 2 category 2 findings within a 3-year period results in a category 1 finding. And that custodian, that staff member who had those 2 category 2 findings substantiated against them within a 3-year period of time, they are placed on the staff exclusion list. However, if a category 2 finding is not elevated to a category 1, those category 2 findings are sealed after 5 years. So if there's a category 2 finding in June and in September, there's another category 2 finding against that same subject, together those would be elevated to a category 1. However, if there's one in June and no others, after 5 years, that would be sealed. After 5 years of period of time, that category 2 finding would be sealed. Okay. So category 1 findings are the most egregious finding that a subject or custodian would be held accountable for. These involve serious physical abuse, sexual abuse, or other serious conduct by custodians. There are 14 types of conduct that fall under the category 1 umbrella that are defined in the law, and substantiation for any of these would result in placement on the staff exclusion list. The names of the staff with substantiated category 1 findings are not publicly available. So, some information about the staff exclusion list. Over 900 people are currently on the staff exclusion list, and more than 320 checks have resulted in a provider being notified that the applicant was on or is pending placement on the staff exclusion list. And we'll talk in a little bit about what this pending placement means. So if a person is on the staff exclusion list, that means that that person is prohibited from being hired by any state operated, certified, or licensed agency that is or provider that serves individuals with special needs. Oh, let me see if I can. Okay, so I can walk through this. This is 2024 data. And basically what it says is in 2024, 39% of abuse and neglect cases were substantiated. So out of all the reports you heard earlier, how many reports were made to the Justice Center and how many of those were made into abuse and neglect? Out of those, 39% were substantiated. 71% were substantiated as Category 3 findings. 21% were substantiated as Category 2 findings. 6% were Category 4 findings, and 2% were substantiated as Category 1 findings. Okay, so at the conclusion of this process, when we have a determination to share that is final, we make notifications. We notify the family members or personal representatives and or the victims if the victims are self-advocating. We notify the provider. We notify the provider's state oversight agency, and we notify the subjects. And then out of a substantiated report, and even an unsubstantiated report, but out of a substantiated report, there are typically there's typically an expectation that there's some corrective action plan that is going to be put into place as a result to prevent further occurrences. And the Justice Center does conduct audits of corrective action plans for substantiated allegations of abuse or neglect. And CAP audit finding letters are sent to providers and copied to the state oversight agency to share the audit findings and any recommendations made to reduce the future risk of abuse and neglect and to improve the quality of care.
Hi, Serena. There's a few questions.
Okay.
We've had a number, right, and we'll get them done right before the break. We've had a number of questions about, when does a staff person get placed on administrative leave? What if, if they're substantiated, who fires them? We want to make it clear, we do not tell providers what to do with their staff or when to put them on leave. There are specific regulations that may pertain to that, and we leave it up to the professional knowledge of the provider agency, unless it's a Category 1 finding, and then the law requires that you be placed on the staff exclusion list and not work with these vulnerable individuals. By the way, the staff exclusion list is only for New York State, not for other states. The CAT 2 findings, if we have two CAT 2 findings, Serena, does it have to be for the exact same offense, or can one be psychological and then the next CAT 2 would be physical abuse?
That's a good question. So the second Category 2 can be for any offense, any victim. It's basically what needs to be the same is the subject and fall within that 5-year, 3 to 5 year, 3-year time frame, but 5-year time frame.
Serena, continue on.
Thanks, Devin. So now we're going to talk about what happens after a final determination has made from an investigation, and that is the appeals process. So following the closure and a letter of determination being sent out of following an investigation, the subject of a substantiated report of abuse or neglect, regardless of the category finding, has the right to challenge that finding within 30 days. To request an appeal, there's nothing that's a specific form or nothing elaborate is required. All we need is it to be dated within 30 days of the date of the determination letter, have the VPCR case serial number, which is at the top of the notification, which is on the letter of determination, and then just say, I want to appeal. You don't have to include any reasons, but a person can if they want to. So here's what happens if a subject does request an appeal. The subject requests an appeal. The case is sent over to our de novo unit, which is completely separate from the case review and closure unit. The de novo unit looks at the case completely fresh, not looking at the findings of the reasons behind or anything regarding that determination that was made before, but kind of taking a new look at it to see if they believe that a preponderance of the evidence supports a finding of abuse or neglect. And a preponderance of the evidence means more likely than not. So 51% likely that abuse or neglect occurred. If the appeal is denied, so if the de novo unit decides that there is abuse or neglect, then a fair hearing before an administrative law judge is scheduled. So there are multiple possible outcomes of an appeal. First, the original finding could be upheld, and so the substantiation would be upheld and the category level would remain the same. Or they could amend the substantiation by reducing the category level. So once something goes to an appeal, the category level will never increase, but it could decrease. Or third, findings are unsubstantiated entirely and the record is sealed, like all unsubstantiated findings are sealed. So to look at the appeals process guidance, this is on our website. And at the top of our website, you can see that there's a section for providers and staff. And if you go to that, it will bring you to, you can choose the administrative appeals unit and process. And there's a handy guide here that will kind of walk you through this process in greater detail.
Thank you, Serena. A couple questions. Does the Justice Center notify the Office of Professions when a licensed professional is substantiated for a case of abuse or neglect?
That's another good question. So we have an internal process regarding cases in which there's a licensed or certified professional with a substantiation. And depending on the specific criteria that we have in place, if they're met, then we would make such a referral. However, we are not mandated to make referrals, and the provider may also make referrals or other individuals as well.
Thank you. Can a victim or a guardian appeal an unsubstantiated finding?
So we see this a lot. The only person who can substantiate a substantiated finding is the subject themselves. However, if the victim or family or provider or others feel strongly, they can work together with the subject and support them through that process.
Thank you. And there was a question, if somebody is a subject, can they bring an attorney to the interview? And yes, we will honor that. We just need to work that out with you. And then finally, for all the questions about how long does an investigation take, it varies. We strive to get them done within 60 days. For many cases, that happens easily, but sometimes there are cases that are more complex and it can take longer because we want to make sure we talk to victims and all the witnesses. All right. On to the next section.
Good morning. I'm Sarah Del Marter, the Director of the Justice Center's Mortality Review Unit. Next slide, please. In addition to reports of significant reportable incidents and allegations of abuse, there's a requirement to report to the Justice Center certain deaths. Those deaths that need reported to the Justice Center, regardless of the circumstances that led to the death, include deaths that are linked to a residential setting that is licensed, operated, or certified by OPWDD, OASAS, OCFS, or OMH. There's also a requirement in our statute that if the death occurs up to 30 days after a discharge, those deaths also need to be reported to us. And I know there was a question earlier about, do multiple agencies need to report the deaths? Each agency that was involved in their residential or inpatient care in those 30 days prior to the death, up until the death, need to make a separate report. Anytime a day program or a non-residential setting feels the need to make a report and share information with us about the death, we value that information too. So outpatient facilities or day programs may call us and report what they know about that death. It's always valuable information to us, but the requirements are that they're reported by anyone linked to their certified inpatient or residential care at the time of death or within 30 days of death. Next slide. What is the provider's role in these death reports? The first is to make a report to the VPCR as soon as there's an awareness of the death. A designee from the agency with some awareness of the death and awareness of the person receiving services, making an informed call report or a web form through the same process as any other incident report that goes through the VPCR, through the call center and through the VPCR. So those deaths, as soon as there's an awareness. Then there's a second obligation for the provider within 5 days, 5 business days, that a complete report of death form is also submitted to the Justice Center. So that report of death form gives us a bit more background information than maybe the caller has about their last 90 days, about their diagnosis, about maybe why they went to the hospital, what medications they were on. It's a form that, if you provide services through OPWDD, is embedded in IRMA, your database. If you work for OMH, it is embedded in the NIMERS database. It's also available on a link through our website to submit the form. We accept them in the mail. A family provider in an OCFS setting might be handwriting the form and sending it to us in the mail, and that's okay too. The forms may look a little different based on which state oversight agency and whether they're designed into a database, but they all ask the basic same questions that help us complete a mortality assessment. The next important thing to know as a provider is that any mortality or incident review activities that you're expected to do by regulation, we expect that you're continuing with those. There is no automatic assumed forbearance because you reported the death to the Justice Center. If you reported a death that is a reportable death because there's a significant incident attached to it, you're expected to provide a significant incident level of investigation and activities. If it's a mortality review, you're conducting yours alongside ours. And if you've made an allegation of abuse or neglect within your call narrative, then that follows the same process that we talked about earlier about abuse and neglect non-death cases. So when a call report comes into Dave and his team, and I think he mentions over 1,600 calls came in, if that call includes a reportable significant incident, it gets classified as such. If it includes an abuse or neglect allegation, it gets classified as such. As you know, any abuse neglect cases that are led by the Justice Center, including deaths, do get forbearance. Next slide. Our mortality reviews have been about 1,500 in the last year that we got all the way to closure. As you can see over the years, the number fluctuates a bit. This, of course, encompasses all 4 of those state oversight agencies. And this does not reflect that they all had reportable incidents in them. These are the administrative reports that the death occurred, that our team conducted assessments on, and some of them had reportable incidents inside them that had to follow reportable incident tracks. Next slide. What do our mortality assessments look like? We review the incident call reports that we receive about the death. We review that completed report of death form to give us additional details. We ask the provider for select additional records. We get the official cause and manner of death whenever possible. And then we also follow up to review the provider's incident review materials on the death. The point of our assessments is to help the provider and help the Justice Center ensure there are no unreported reportable incidents related to the death. Next slide. Often our mortality cases are closed without concern, and a simple letter is sent to the provider that we did not identify concerns with the death from the level of review that we conducted as an assessment. However, sometimes there are outstanding concerns from our mortality cases, and those lead to further actions from our unit. The first is we help the provider identify, or we identify, a reportable incident, and that goes back through the same process as any other reportable incident. If a significant incident is identified, it needs reported, classified, and investigated according to agency regulations and state oversight regulations. If we identify abuse neglect, that follows an abuse neglect track. If we identify a need to report to an outside agency, such as a concern with the hospital ER or something like that, we may make a report that delegates that investigation to the Department of Health. If we find less than a reportable incident, but we find an area where we can recommend that standards that we're aware of should be followed or could help a quality improvement, when we close, we will send the provider a letter with recommendations. If we do provide recommendations in our closure letter about standards of care that could potentially improve services, we will also copy in the commissioner or their designee for the state oversight agency. A third avenue is we have access to a medical review board of volunteer doctors who can help us identify if there are standards of care at the physician level that we should be involved in making recommendations in order to give those doctors the clearest picture of what we know. Sometimes we conduct site visits and interviews. As I used the term earlier, we primarily do mortality assessments, but if we go into a full review in order to share the best input for a medical review board to give us and the providers recommendations, we may need to make a site visit, we may need to conduct interviews. Next slide, please. Our medical review board is made of up to 15 voluntary New York State licensed physician members. They are tasked with helping us make preliminary determinations whether a death is deemed unusual and warrants investigation. As we mentioned, a lot of that work, because of the volume, is delegated to our investigative team to make the assessments, to review the information, and to help identify reportable incidents that do need further investigation. But then some select cases each year are provided directly to the medical review board for their review. And as a collective, they help us with medical opinions, with medical education about the circumstances of the death. And they help us identify either reportable incidents in need of substantiation or they help us identify recommendations to give back to the field.
Thank you, Sarah. There's a couple questions that came in. Are care coordination organizations required to report deaths?
They are not. However, we value those calls and we do get a significant number of them. As care coordinators, you're in the home, you know the people that you're serving, and you may know something about the death, and it's always a valuable call. Intake, although they recognize those calls may be non-reportable, they do link them to our death reports so that we can see them and we can reach back out. So we appreciate non-reporter and non-required calls on deaths.
Thank you. I also just want to make sure that, we emphasize again, there was a question. All deaths are reportable, even those that are due to natural causes, even somebody who's in hospice level of care. There have been a couple specific questions about where do I get information about a final letter of determination, et cetera. At the end of this presentation, we have contact information for you to follow up and contact the Justice Center about those very specific questions. All right, the next presenter, we're ready.
Good morning, everybody. We are in the home stretch, so thank you so much for hanging in. My name is Paula Branca Santos, and I am the Special Prosecutor and Inspector General here at the New York State Justice Center. And I want to talk to you a little bit about my team's role here at the Justice Center and how we really coordinate with all the folks that you've seen here on today's call and the Justice Center as a whole. So when we start talking about the role of the Special Prosecutor, we talk about criminal investigations. And that kind of takes you back to what Chief Tony Ryan talked to you about earlier about the nature of investigations. So I'd like to just go through the bullet points and then I'll give a little bit of an explanation as to how practically we work through that. So this team, the team of the Special Prosecutor Inspector General, is made up of Assistant Special Prosecutors, all of whom currently are former Assistant District Attorneys from District Attorneys' offices throughout the state. And our main concern is to review cases that come in and analyze them to determine if elements of criminality exist according to the New York State penal law. At the outset, this involves working hand in hand with our Justice Center investigators, and then we look and determine whether or not it's time, whether or not it's feasible to connect with the local DA's offices. So how practically does that come to fruition here? You heard earlier from Incident Management Unit, you heard from the Office of Investigations how cases come in. So after the case comes into the Justice Center, from the call center. They are reviewed, and if it looks like there may be elements of criminality or something that requires an extra level of attention and analysis, that will also come into the special prosecutor's queue. And we distribute those cases to the assistant special prosecutors throughout the state, and we take an extra look at them and collaborate with the investigators. And we work hand in hand to say, okay, are these elements of what looks like criminality enough that rises to the level of attention of a district attorney's office? And that's going to be determined by looking at the elements of each of those allegations as they fit within the New York State penal law. We then, if we decide that they do, we make a notification to the district attorney's office if they haven't heard about it already. Some cases will come in, and those are the most egregious, and they will come in and already have been brought to the attention of the district attorney's office. One thing I do want to discuss very briefly is something that Chief Ryan talked about. It was a question that was posed to him about how do we, or somebody asked something about the interviews. You know, do you do the interviews? Why wouldn't the provider in certain instances do an interview? It's really important because we in law enforcement always look for fundamental fairness, and that is fundamental fairness with respect to the victim. It is always a victim-centered approach while balancing the fundamental fairness to the accused. And those do, by and large, come with one solid interview. There are always going to be times when there may be a need for additional interviews. But to the extent that one solid interview can be done, that's the way that it should be done. And it should be done with extensive collaboration. So when we, which is number 3 on the bullet point, work with the district attorney's offices throughout the state, we say to them, listen, we would love to, and we have an obligation to, under our mandate, assist and cooperate with the district attorneys throughout the state. And in doing so, we think it would be a great idea if we work together. Let's get on a call. We will talk about what we know here at the Justice Center and about the facility and about the allegation. We can connect our investigators with the police departments that are working the case, or the detective investigators from a particular district attorney's office. The assistant special prosecutors can talk about the different laws that are available with the prosecutors working at the DA's office. So a collaborative approach is the best approach for a full and fair case for everybody involved. Now, when we're talking about this collaboration, we look at how many cases are really classified criminal. And it's interesting that this percentage, right, the less than 1% of cases are classified as criminal here at the DA's office. Now, classified as criminal has a couple of meanings. When we classify a case criminal, we're not necessarily saying there's going to be an arrest. We are saying it is classified as such that we believe elements of criminality exist that are enough to go to the DA's office with. But what's interesting about the 1% number is that it corresponds to the percentage that I believe that Serena spoke about that are Cat 1s, right? And that's because it's the most egregious. It's the worst of the worst that you can imagine. So there is a corresponding level as to what can be charged versus what is going to be substantiated as a Category 1 offense. In considering this victim-centered approach and all of the collaboration and the cooperation and the analysis that goes into these cases, if during the conferences with the investigators, we determine either that it's going to the DA, like I've spoken about, or that there is not enough for a criminal charge, either determined by us and or the district attorney's office, as Chief Ryan indicated previously, there will always be this parallel administrative case that's going to move forward. Sometimes, oftentimes, if we collaborated well, which we always seek to do so, we will be able to use the information in that collaborative approach for the administrative case. And that's the best case scenario. So the administrative case will always move forward. And we tell our partners in law enforcement that from the outset, because we want them to know that, you know, yes, we are all working together, but down the line, no matter what happens with a decision on the criminal end, we are going to move forward. So the prosecutors, the assistant special prosecutors in our unit also work with the investigators to make the best case possible on the upfront so that the lawyers down the road have the best case possible to move forward should there be an appeal. There was a question earlier about how long it takes for cases to close, and I believe that Davin is the one who answered that question and said some cases are more complex, and the complexity of those cases are for sure the ones that are determined criminal, and that is because sometimes we hold while the criminal prosecutions are pending, and those certainly take longer. However, our default is to move forward with our case, and we work with the district attorneys to make sure that those can both be done in a way that does not impair the integrity of any case that is going forward criminally.
Thank you, Paula. A couple questions came in. What's the process? What do we do when a victim is nonverbal?
Excellent question. So we have many ways of corroborating cases. So I think that the first and foremost, we look to corroborate an allegation to the best of our ability. And what that means is if an allegation comes in that something happened and it happened in a certain part of the facility, we'll say, okay, is there a video in that part of the facility? We'll look to corroborate by what I always love to call little nuggets. Can we get a video that corroborates that it happened at a certain place? Maybe you can see them together. That would be corroborative. Obviously, the questioning of witnesses. I know there was a question before about can it come in anonymous? Yes, of course, it can come in anonymous, but the more access we have to witnesses, to reporters, the better the case we can make, especially for somebody who is nonverbal. And in some instances, depending on the nature of the person receiving services disability in terms of being nonverbal, if they can use assistive technology, we do have people that are trained in using assisted technology.
Thank you. If it's a criminal case, does the subject have the right to know what the charges are?
That would be up to the district attorney's office. We would never divulge what if any criminal charges there were. We would refer that question to the DA.
Thank you. And the last question, can legal guardians refuse criminal prosecution of perpetrators?
Can legal guardians refuse criminal prosecutions of perpetrators? So the short answer is no. So when a person is prosecuted, when there is an arrest that's going to be made, it is the people of the state of New York versus so-and-so. And so a criminal prosecution can go forward without cooperation of the victim or their legal guardian. Now, of course, I don't want to speak on behalf of the district attorney's offices throughout the state, but having sat on that side of the desk for many years, of course, we take that into account. We look to see if the case can be proved without cooperation. And of course, we look and try to understand why it is that a family legal guardian would not want this prosecution to move forward. Okay. Moving forward, we're going to talk about prevention of abuse and neglect, because at the end of the day, that's really what all of us want here, right? It's great to know the statistics. It's great to know, what you can do once the process is rolling. But imagine a world where the process didn't have to roll and none of the people receiving services in these vulnerable population were harmed, weren't subject to abuse or neglect. So to that end, the Justice Center has had many great initiatives, and one of them is the Spotlight on Prevention. And I encourage everybody on this call to please look at our website and connect with us on LinkedIn. We have agency self-assessments. There are tools that support program efforts to develop a comprehensive approach to prevent abuse and neglect. There are other trainings that talk about best practices for an abuse-free environment. These are strategies for creating such environments. Sometimes you don't even realize that there are just little kinks in the day-to-day flow of things that if they're removed, you take away a large segment of issues that could come up. And then there, of course, are code of conduct trainings, ethical guidelines, so to speak, for caring for individuals receiving services. We have all of these toolkits available for you. Again, they're on our website. They are on, from time to time, we post them on LinkedIn again. So please follow us on LinkedIn, where we talk about body checks, how to do them appropriately, what are red flags and body checks that somebody who is in that position may be looking for. What are the dangers to being left unattended in vehicles? You know, we talk about it with children all the time. You talk about it with animals, right? Our beloved pets. You saw the 5-minute video. We're talking about the same with people with disabilities who have special needs. And there are real severe dangers to that. Caregiver fatigue is huge. Nobody, you know, in that case, somebody may say, I didn't mean to do it. And that is so true. But then this prevention toolkit can help you. How do you take care of you? Because if you don't take care of yourself, you can't take care of somebody else. We talk about obstructions, securing wheelchairs and vehicles, the use of restraints, that's a big one. All of these toolkits are here for you. What to do in a medical emergency. Maintaining professional boundaries is a big one. We have a lot of people, very well-intentioned, who are custodians who get close to the people receiving services, but we have to remember at the end of the day, there needs to be a professional boundary set. So these prevention toolkits can help with that for your staff members or you if you are working in these facilities. Talking about effective medical care, again, the abuse-free environments, their choking prevention for individuals who have swallowing issues, gastrointestinal issues, and then a corrective action plan for guidance. And here is the much awaited contact information. Again, these will be available to you. The PowerPoint will be made available to you. So please, we encourage you to take advantage of giving a call to any one of these units that you may need assistance from. Thank you.
Thank you, Paula. We really don't have any questions left. You know, except for one person who wanted to know if we investigate serious car accidents, and we investigate anything that is reported to us where somebody who received services has risk of harm, was harmed, or there's likelihood of harm.